Lordship, I beg to mention item 3 and 4, Your Lordship. Beg to mention item 3 and 4, Your Lordship.
Why?
Lordship, on the last occasion,
Forest colony matter.
Forest colony, Your Lordship, yes, correct.
I think last time this court has made it clear that this matter will not be adjourned.
Lordship, actually, what happened last time, Lordship, has insisted on adjournment, Your Lordship, and one of our colleagues, Your Lordship, is conducting the hearing, Your Lordship. So, Lordship, we still require some more time, Your Lordship, to prepare the matter.
There is no interim.
No, there is no interim, Your
You
Lordship.
have not.
Lordship, in fact, we have them to go ahead, but still
Since,
they are not
since the lease
already expired a long time back, Your Lordship, yes, long time back. But since they are not, because of the pendency of this, so they don't. Lordship, you know, they are,
there is no.
it's true, Your Lordship. There is no interim,
no interim
restriction, but still, department they said that in view of the pendency and all.
It's taking a long time.
It'll be next week then, Your Lordship.
On plea made by the petitioner, seeking accommodation on the ground that the learned conducting counsel is indisposed on grounds of personal difficulty, matter is adjourned. This might have to 1 week.
Obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 10. Your Lordship, we pray that this matter may come up after 2 weeks since the conducting
is
senior
item 10?
counsel is on sanctioned leave, Your Lordship.
You are in the case.
Yes, Your Lordship, we are for the respondents.
Then you can do it.
Your Lordship, the
It
senior
doesn't mean,
conducting
you see,
counsel.
it doesn't mean that if one counsel is not available, matter has to be adjourned.
Your Lordship, we don't have instructions of senior counsel. He is the conducting senior counsel.
May I? Lordship, this is Mosika has been engaged as special counsel for the state, Lordship.
I have no objection, Lordship.
We are representing the state.
Okay, we state.
State, Lordship.
Yes, Mr. Kanta?
Something is wrong with the net.
Nothing is
No
wrong.
objection,
I
Lordship.
can hear you perfectly well. Mention is made on behalf of Dr. Elmozika.
No objection, Lordship.
Noted. On behalf of Dr. Elmozika, who is said to
I
be
have no objection, Lordship.
either
Something is wrong.
he can't hear me or I can't hear.
She's here.
So sorry.
Your Lordship, we have no objection.
I've heard your senior, I've heard you. You are the petitioner, so if you have no objection, we'll list this matter after 6 months. Om Nundu? On sanctioned leave. Mention is made on behalf of said to be answered and as such could not appear for this court today. Adjournment is accordingly sought for, to which the petitioner has no objection. On pre-made seems allowed. This is matter up to 3 weeks. Thank you.
Supplementary course list, item number 1.
May it please Your Lordship. Lordship, I feel it's my duty to bring to your Lordship attention, Your Lordship. Lordship, in the earlier round of litigation, Your Lordship, this court mostly had recused from hearing the matter, Your Lordship. That has been reflected, Your Lordship, in the order passed by the then Honorable Chief Justice, Justice Banerjee, Your Lordship.
I'm aware of that.
Lordship.
Lordship,
So far myself, I have no I have no problem, Your Lordship. I have no objection, but just to bring into Your Lordship notice.
Lordship, just two very small things, my Lord. In 2018, Lordship is aware, 2018, earlier round had started. Today's petitioners were respondents there. I understand, my Lord, I was not involved, but I understand Lordship's relative was one of the respondents. So Lordship at that time had correctly recused himself. Today, my Lord, Lordship's relative is not part of the cases, my Lord. He is not involved in any manner.
See, Mr. General.
Yes, my Lord.
I have gone through the.
Yes, my Lord.
What is impugned?
Yes, my Lord.
Is the gradation list.
True, my Lord.
To which my brother is also. His name appears. So
I understand.
you can understand.
I understand.
In all fairness.
Absolutely.
See, there should not be even an iota of.
Absolutely. We completely agree.
You understand.
Absolutely.
The issue of bias will always.
Absolutely. Very well.
It may be there, it may not be there.
It will not be there. I'm certain of that. But
it would be perceived.
The appearance has to be.
It would be perceived.
Yes.
Other they may have some reservation also, Your Lordship.
Very well.
Because they were the respondent here, they were the petitioner in the earlier round of litigation, Your Lordship.
The point is this: at the end of the day, what happened is you may gain an advantage, or it may be a disadvantage to you.
Yes, my Lord. It could work either way, but we completely appreciate Lordship's reluctance. Lordship can pass necessary orders.
At the outset, the AG, Mr. Dishulai has fairly pointed out that this court in a similar matter involving a similar issue which is also raised in this petition, wherein this court has recused from the same, and therefore a question has been asked as to whether it would be proper for the court to take up this matter under these circumstances. In order to convey a clear message to the parties concerned as to the fairness of the proceedings, whether perceived or otherwise, this court is accordingly of the opinion that the matter may not be able to be taken up. The matter may not be able to be taken up. It is the opinion of this court that it is the considered opinion of this court that the matter cannot be taken up by this court. This is the same before any other. Should I, pass a remark that the matter is to be listed before any other bench, or should I just leave it like that?
Before any other bench.
Let it be.
Eventually, it may be put up before the Chief Justice.
Let it be passed, Your Lordship.
Before any other bench, my Lord.
Of course, that is usually the remark that we give.
The last concluding remark.
Any other bench?
Oblige, Your Lordship.
From daily list, item number 1.
You keep on there.
May I please, Your Lordship? Your Lordship, I humbly pray that this matter be taken up tomorrow, Your Lordship. Because as Mr. SD is still having the hearing on in next to courtroom 4, Your Lordship.
How long will it?
It will take time, Your Lordship.
It will take time.
Yes, Your Lordship. Friday,
Ms. Learned Counsel for the petitioner has submitted that the learned senior counsel who's conducting the matter is on legs before another court and could not be present when this matter is called up. It is prayed that the matter may be adjourned for the day. 1 week? Premier, this is matter to 1 week. Fix date no.
Item number 5.
Two cases, my lord. Both cases are the main issue is regarding prolonged suspension, my lord, from 2014 till date, my lord, and no disciplinary proceedings. This matter has a long history, my lord, but I will not trouble your lordship by going into the entire history. So I will just hand over a list of dates, my lord, for the convenience of your lordship. What I have handed over is the next item, my lord, writ petition, item 6, writ petition 456 of 2020.
What about this 455?
455 also I have, my lord. I have prepared my notes in this.
No, but are they
Exactly similar, my lord. Exactly. Both are teachers of aided school in the same school. And, my lord, there was a dispute regarding, my lord, managing committee regarding the school, my lord.
So we'll go first with the
my lord, item 6,
Item
writ
6.
petition 456 of 2020. List of dates. Notes so this particular petitioner, my lord, as on date is 54 years old, my lord.
54 years old.
54, so hardly, my lord, 4 years to retirement, my lord, left. So, my lord, in the list of dates I have, my lord, indicated in 1988-89, my lord, this St. Mary's Roman Catholic Primary School was established, my lord.
Yes.
And, my lord, in 1994, the private respondent number 7 was nominated as a secretary. Private respondent herein, my lord, who has not been appearing despite service, my lord. But he has no role in this particular issue.
Okay.
He was a secretary then, my lord.
Secretary of the managing committee.
Of the managing committee of this particular school, my lord.
Who's representing the managing committee now?
A managing committee, my lord, Mr. Sangreso is appearing. So, my lord, in 1995, my lord, the petitioner was appointed, my lord, as assistant teacher, my lord, to the school. Now, somewhere in between, my lord, in the early 2000s, there was a dispute, my lord, between the respondent, private respondent number 7 and the private respondents. So, and the present managing committee, that is respondent number 6, my lord. So there was a dispute between 6 and 7. Now, my lord, during our appointment, at that point in time, number 7 was the secretary, my lord. So despite the dispute between them, what we did, my lord, we stuck to the secretary. We continued to work in the school. However, in 2008, my lord, they stopped payment of our salary. They stopped payment of our salary. Now, when they stopped the payment of our salary, a litigation, my lord, started between the respondent number 7 and respondent number 6 and the state government. Writ petitions were filed, my lord, before this honorable court. And thereafter, my lord, in 2013, we also approached this honorable court for payment of our salary. Now, in 2013, my lord, this honorable court, my lord, decided dispose of the writ petition with a direction to the government to conduct an inquiry, because by then, my lord, by the same name, there were 2 schools. Two schools. One run by the respondent number 6, one run by the number 7, my lord. So we were initially appointed with the number 7. We were receiving salary. In 2008, it was stopped. Litigation was going on, my lord. So ultimately in 2004...
Which school is the recognized one?
Yes, ma'am, I'll come to that. So, my lord, after in 2013, when this honorable court directed for an inquiry was conducted, my lord, and thereafter the state government, my lord, decided the issue. That the school which will be recognized, my lord, which was decided in 2014, is the school which is run by the respondent number 6. So this is 2014. Now, after the decision of the government that the school run by respondent number 7 is not the recognized school, but the number 6, my lord, we wanted to join in that school, my lord. However, prior to that, what they have done is, my lord, they have issued an order of suspension, my lord. I'll just point that out, my lord.
So it's a question of allegiance.
Yes, my lord. That is what they are saying, that we have abandoned all that. But no, my lord, there was a dispute. Now we have to follow one of the schools. We have to continue teaching, my lord. So we continued with the person who has appointed us. That was our fault. At best we can say that was our fault. But after the government has decided, when we want to join, my lord, we are not permitted because we have been suspended. And that suspension is going on till date without any proceedings, my lord. That your lordship will find at page 86, my lord, of the writ petition. Page 86 and excerpt 25. This is the resolution passed by the managing committee of the school, my lord.
Yes.
This is dated 13th of July 2013. Now this was prior to when the government decided the issue, my lord. It reads, my lord, it is hereby resolved by the managing committee of St. Mary's RCLP School, Nonglawai, to initiate disciplinary proceedings against Srimati so-and-so for unauthorized absence from duty since May 2008 till date. It is further resolved that Srimati so-and-so will be placed under suspension pending the disciplinary proceedings with the approval of the SDSEO, Nongstoin, West Khasi Hills. Now, my lord, at page 87 is the approval by the government, by the SDSEO, my lord. This is dated 10th of January 2013.
Yes.
Dates, my lord, slightly confusing. This should have been 2014, my lord, because the previous page was 13 July. The recommendation, page 86. Now, the approval on the next page should have been January 2014 and not 13. So, my lord, it reads, my lord, as recommended by the managing committee dated 13th July 2013 of St. Mary's so-and-so school, the suspension of Miss so-and-so, teacher in the school, on account of her long and continuous absconding from school duties is hereby approved. So placed under suspension. Now, my lord, since then, till date, my lord, no disciplinary proceedings, my lord. I have just been, my lord, suspended till date without any proceedings, my lord. And my lord, this is an aided school. The aided school, my lord, is governed by the Meghalaya School Education Act of 1981. This is the act, my lord, which governs aided schools in Meghalaya, my lord.
Where's the provision for suspension?
Yes, my lord. My lord, page 8, section 9 onwards, this provides for
Yes.
Section 9, my lord, terms and conditions of service of employees of recognized private schools, my lord. So all schools under this act are recognized, my lord, if approved by the government,
Yes.
and some of them are aided. So this is an aided recognized private school, my lord. So section 9 provides, my lord, regarding all this salary and everything, my lord.
Yes.
Subsection 4, my lord, of section 9, second last paragraph,
Yes.
where the managing committee of recognized private school intends to suspend any of his employees, such intention shall be communicated to the competent authority, and no suspension shall be made except with the prior approval of the competent authority. So this they have done, my lord. This they have recommended, and the government has done, my lord. Now, my lord, section 10 at the next page.
Yes.
Every employee of a recognized school shall be governed by such code of conduct as may be prescribed. On the violation of any provision of such code of conduct as may be prescribed, on the violation of any provision of such code of conduct, the employee shall be liable to such disciplinary action as may be prescribed. So, my lord, under section 10, my lord, I can be, my lord, disciplinary action can be taken against me, that is disciplinary proceedings, my lord. So, my lord, in this particular case, I have been put under suspension, my lord, since 2014, my lord, 13, till date without any action, my lord. So that's my case, my lord.
There is no, see, that's why, see, the query of this court is, where are those prescribed
Code of conduct.
code of conduct for as far as disciplinary proceedings are concerned?
Yes, well, code of conduct is the government code of conduct, my lord. In fact, last evening I was trying to locate in my file, I could not find.
See, what is required here
Yes, my lord.
is with reference to this section 10,
Yes, my lord.
disciplinary action as may be prescribed.
Yes, my lord.
So where is it prescribed?
It will be prescribed in the code of conduct, my lord. That I don't have today, my lord.
Yeah.
It's called the disciplinary rules.
Lordship, I don't have. That is their case. My case, so far the state is concerned, we are on a different footing, Your
That is a
Lordship.
different thing.
Lordship.
But
But those,
if it is included in your sets of papers,
I don't
what
have, Your
about
Lordship.
managing
I
committee?
don't
You
have.
have this, Mr. Sariso?
I don't have, Your
It
Lordship.
is, but it is there.
I'm not aware, my lord.
You're not
It is
aware.
there, my
No,
lord.
see, if the act is so, then there must be something.
Whether the government has frame on it.
Then
Disciplinary rules are there, my lord, of the government. That is applicable to these cases, my lord.
Because this is not government, this is government, not school. This is aided school, Your Lordship. Whether those rules will be applicable or not, Your
that would
Lordship.
be see, that would be another question as to whether such rules or
Will
disciplinary
be applicable or not,
proceedings
Your Lordship, yes.
will be applicable.
Lordship, yes.
So
Right now, I don't have, Your Lordship.
be that as it
I
may,
don't know whether such a rule have been framed or not. If that be the case,
Mr.
then, Your
Nombri
Lordship.
says they are.
They are, my lord, and even if they are not, my lord, principle of natural justice will apply.
That is a different thing.
Yes, my lord.
First, you see.
Yes, yes, my
how
lord.
we approach-
I'll have to establish
see,
according
how we
to
approach the issues.
rules. Yes, my lord.
First, if you have been suspended, it should be, you see, as per certain rules,
Yes, my lord.
certain norms or regulation, whatever the case may be, which are prescribed. Here they say the word prescribed is used.
Yes, my lord.
How do we do that?
We can have it some other day, my lord. I'll just locate the code of conduct.
Code of Conduct
It
1990.
is not the code of conduct that is required.
Disciplinary.
The specific prescribed disciplinary rules.
I don't think, Your Lordship.
There
that
must
is-
be.
I don't
Then
think, Your
what
Lordship.
is the point of having-
I'm not come across, Your Lordship.
What is the point of having this provision in the Act?
In the Act.
It is incumbent upon the authorities concerned to frame those rules.
Or it might have been framed. So we also will ask, Your Lordship.
Heard Mr. Liman Longri, and counsel to the petitioner. However, in course of hearing, on a query made by this court, particularly as regard the prescribed rules, disciplinary rules pertaining to the conduct of a teacher of a government-aided school, the learned counsel would submit that it is not in his possession today and has sought for some time for the same to be produced. Accordingly, on prayer made, that is adjourned. List the same after.
Well, 2 weeks. There's a book, my lord, called Education Code of Meghalaya, my lord. I think that contains everything. I've seen that book.
It is there. That is there.
Yes, that compilation, my lord.
I'll check, Lord. I
many
do have
cases
that.
counted, but I don't really.
Yes, my lord.
I'm not
do-
really
It
about
should
this
be there.
case.
It should be there.
Let me check, Your Lordship. I have that book also. Let me check whether that is there or not.
So 2 weeks then.
Lordship.
Deep.
Apply, Lordship.
Item number 7.
Yeah. So have you?
Yes, sir.
On this matter, my learned friend was supposed to furnish the records along with those flags.
Yes. Yes.
This index has given you, Lordship.
Yes. Furnish the records. And these are the flags.
These are the flags and then index given in the first page, Lordship.
Yes. Index. Yes. Yes. Please start.
You know, in fact, my argument is over.
Over.
Yes.
This is the problem.
After my argument, Your Lordship, I asked for clarification from my learned friend.
What is this case about, Mr. Longri? In a nutshell.
In a nutshell, Lordship, here this he was asking for ACRs and then we have given the ACRs and after this
Yes, Your Lordship, this is with regard to ACR whereby denied, my promotion has been denied.
Motion denied.
So thereafter, in short, Your Lordship, against that, I have filed a writ petition
On the
before
basis
this
of negative remarks in the ACR,
adverse remark,
whatever, adverse remark. So,
only for one particular year.
for which such ACR was not communicated to you
Yes,
to allow you to respond.
response.
That is your case.
Thereafter, Your Lordship, I filed a writ petition, and this Honourable Court directed the Union of India to furnish the ACR to me. Firstly, for me to file a representation, and they should consider the representation and furnish me the ACR gradings. And thereafter, if they find that I am within the zone of consideration, they should sit for a fresh TPC and consider for my. But if it is otherwise, then the matter ends. Now, what has happened here after this Honourable Court remanded back the matter to the Union, I submitted my representation. They furnished me the ACR, which is an incomplete ACR. Thereafter, then I submitted another representation to consider me for promotion. They rejected my representation by a way of a speaking order. Now, while rejecting my representation, not considering my promotion, the only there was no findings as to why I was not considered, number one. And number two, the second ground they have come is that if we grant you promotion, there will be a floodgate and there will be other people coming. So in my humble submission, Your Lordship, that cannot be a ground.
See, promotion is personal.
It's personal.
Why would you? I don't see any logic.
And Your Lordship, I have relied for some Supreme Court judgment also whereby they cannot take that ground. Because this is a matter of something personal.
It's personal to the officer, yes.
My fundamental right is being infringed, I ought to be granted to protect my rights. But they cannot take that ground that if I am granted, the rest will.
How do you see that the ACR communicated to you is incomplete?
Your Lordship, I'll take Your Lordship how it's been communicated to me. The entire entry by all the inquiry officers has not been furnished to me.
So the issue, firstly, the issue is incomplete ACR, on the basis of which the authorities concerned has rejected your representation.
Yes. Judgment. Your Lordship, that is at page 84, annexure 10. This has what been furnished to me. Single page. What it was called? Inquiry.
What are these 7R, 5R, 5R, 7R?
These are the rating you see.
Gradings. This has what been furnished to me after the directions of this Honorable Court. Normally, Your Lordship is well aware while furnishing the ACR grading, it should be accompanied by the gradings of the initiating officer. Thereafter, it goes to the reviewing officer. Then it goes to the senior reviewing officer, as provided in the rules. Now, the rules, Your Lordship, I have annexed at page 29.
29.
Page 29 of the petition. Page 29, Your Lordship. Down in the bottom.
Where's the type copy?
It's legible. Your Lordship has got it. Page 29 in the bottom. Rule 40. Communication of weak points. Your Lordship has got it?
Yes.
I'll read, Your Lordship. Weak point, adverse remarks of reporting officer in the CR will be communicated to JCO in writing. Remarks of reviewing, senior reviewing officer, where applicable, will be communicated in writing through the initiating officer.
If there is an adverse remark, that would, how would it be translated in as far as gradings is concerned?
So now I'll take Your Lordship to page 84 again.
Yes.
Page 84, 2013, 14, 15, 16, 17. The gradings are 7, 5, 5, 5, 7. Now what I am required eligible for promotion is that I should have 7R on 3 counts. Here I have 3, 5. By which by 1 year I am short of my promotion eligibility. So I have secured only 5 points. So now these gradings, if it has to be furnished to me, the adverse remark, the entire bunch of the ACR should have been furnished to me.
No, again, you see, where the specific, the specific format as far as the gradings are concerned.
That is the rules. That will find in the rules also, Your Lordship.
Suppose if 5R means there is some adverse remark.
Yes.
Or it means below average, or that has to be spelled
I'll
out.
take Your Lordship to that.
7 is the maximum.
That I've quoted in my thing. Page para 4 of my petition. I'll read, Your Lordship. Para 4.
Yes.
The petitioner further states that the 9-point system of ACR criteria is being followed for promotion to the rank of Naib Subedar, Subedar and Subedar Major, as provided in ACR policy framed by the respondent number 2, White ROI number 4 of 1997. Is as follows. Now, Your Lordship, outstanding is 9 points. Above average, 7 points. This I have secured on 2 occasions for the year 2013 and 17. Now above average 7 points, high average 5 points, low average 7 points, low average, average so 4 points, low average 3 points, below average 1 point. Now next point, Your Lordship, para 5. The petitioner states that as per letter dated so and so, dated 25/6/2012, the ACR criteria for promotion inter alia from the rank of Naib Subedar to Subedar to be effective from 1/1/2003 as follows. 3 out of the last 5 ACR should not be below above average. That is minimum 7 points. 3 above average, Your Lordship, the grading is 7 points. 3 out of the last 5. The remaining 2 CR should not be below high average. That is 5 points. Now my case here, Your Lordship, above average I've already secured 7 points on 2 occasions, 2013 and 17. Now the remaining 2 CR, last 3 years I should secure 3 times 7 points. That means for this 5 years, at least for 3 years I should get 7 points. But my case here, Your Lordship, is that the remaining 2 ACR should not be below high average. In my case is that out of the 5 years, 3 is above average. Whereby they say that in one of these years there is an adverse entry. So that adverse entry was...
Where's the communication to that effect? That there is There was
There was no communication. That is,
now you're saying that they have communicated to you that there was an adverse entry?
yes, I've read, Your Lordship, Annexure 10.
Oh, that Annexure 10.
Yes.
Yes. Where is it?
Now, Your Lordship, point number 2. As per headquarters, DJR letter so-and-so, 29 December 2016, regarding ICR criteria for promotion.
This is only the grading that was given to you.
Yes.
But where is the reference which says that there was
Your
an
Lordship,
adverse?
kindly go to the remarks below.
Okay.
Not recommended on the right hand corner. Not recommended due to JCO lacking ACR criteria out of the last 5 reports. 3 reports must be above average, that means above 7 grading, and the remaining 2 high average. Whereas JCO, that means me, earned only 2 reports of above average gradings, and the remaining 3 reports are high average. This was the only communication to me. Whereas the rule says if you have to communicate, it has to be in writing. The rule says, I'll read that again. Page 26. Page 29, sorry. Rule 40. Weak point adverse remark of reporting officer in the CR will be communicated to the GCO in writing. Remarks of reviewing senior reviewing officer were applicable. Now here, Your Lordship, while furnishing the ACR, it should be independent. One from the reviewing officer, senior reviewing officer, and initiating officer. There should be an independent remark by them why I'm not eligible. That entire thing was never furnished to me. Just a letter. Why? Just a remark that since I have only 2 high average, that's why you're not considered for promotion. So basically 2 contentions. The ACR has, despite the orders of this Honorable Court to furnish the entire ACR to me, that was not done, but communicated by a communication letter. 1. And number 2, while passing the speaking order, there was no finding as to why I have not been granted promotion. But saying if I am granted, it shall open a floodgate for other officers.
Come again, where is the so-called speaking order?
My Lordship. That, Your Lordship.
11? No, not this.
Annexure 12, page 90.
Speaking order.
Though it looks lengthy, Your Lordship, but it's a repetition of the same from the beginning to the end. They've quoted the High Court judgment and quoted the rules. What is the length of service? After that, there is no finding. Why I should not be granted. Now point number 6. The finding should be here. Point number 6, the Lordship of the speaking order, page 92.
Yes.
Now, therefore, keeping in view of the above facts in mind, the competent authority is of the considered opinion that the duly constituted promotion committee, after considering the entire service record and last 5 years ACR of so-and-so, has rightly not recommended him for promotion, as he has been found ineligible for promotion to the rank of Subedar due to lacking of ACR criteria. The request of the petitioner, next page, Your Lordship, for upgradation of his ACR grading and or to ignore weak points has also been examined, and it has felt that any alteration or upgradation in the gradings earned by the petitioner in his ACR for the years 2013, 14, 14, 15, 15, 16, 16, 17. At this stage would set a bad precedence and bad paradigm in the force, as a number of employees who have been superseded for promotion similarly will also plead for upgradation of their ACR, citing his case and example, which shall however will reopen a large number of cases and would not be in the interest of the organization. So basically, they're only to protect their organization and violating the fundamental rights. Now, on law points, the Lordship is well aware that uncommunicated ACR cannot be taken at the time of promotion, Your Lordship, when the same has not been communicated. That we have judgments of that of Sukhdev. Your Lordship is well aware, has relied also in few cases of Mr. Manik Chanda, Your Lordship.
Yes. Have you filed your written argument here?
Your Lordship.
Have you filed your written argument?
Oh, no, not yet, Your Lordship.
Mr. Devnath, you've been heard in this matter.
Yes.
Not only the only new development is that, Your Lordship, I am entitled from promotion from 2019. This post, which I'm supposed to get from 2019, I've been granted only in April 2022. So my contention now, it's only for that period of 2019 to 22, the benefits and the retrospective promotion.
Oh, that is a subsequent development then?
Yes.
But have you brought that on record?
Yes, Your Lordship is well aware about it. You've taken instruction here, he has informed the court also. I'll put that in my written argument also.
In course, you see, in course of argument.
It's recorded in the order sheets also, Lordship. I'll take Your Lordship to the order sheets.
But it may not be the proper course. You see, if there are subsequent developments, you should have brought it by way of an affidavit.
Your Lordship, order dated 16/2/2024. So and so, Learned Sages submitted, he may be allowed to seek instruction as to how to proceed in this matter, particularly in the light of the fact that he has since been promoted, though only in the year 2022. My prayer in the writ petition, Your Lordship, is from 2018.
This fact may have been brought to the notice of the court.
Your Lordship.
But it would be incumbent upon you. If your claim now is for consequential benefit vis-a-vis from notional promotion, if at all, with effect from 2019, then you have to amend your prayer.
That it can be done now. I can file a small synopsis written argument along with that.
No, that will not do, Mr. You have to file a proper affidavit. You have to file a proper affidavit, amend the prayer.
Prayer, Your Lordship, is already there. Can you see the prayer in my writ petition?
No, as far as the
I have to bring on record only that I have been promoted subsequently. That is all.
you have to
Otherwise, the prayer is already there, Your Lordship. Page 12, Your Lordship. Page 13.
yes.
Issued quashing and setting aside the impugned speaking order 29/2022.
So you're seeking promotion retrospectively from 2018.
Yes, Your Lordship. Consequential benefit including seniority with retrospective effect from 16/7/2018. My prayer is already there. So I'll just bring on record when I was promoted. That is all.
And also file a written.
I'll file that. I'll bring on some case laws also.
I don't think you will, because you have brought that to the notice of this court. So if he brings it on record by way of an affidavit, I don't think you will respond to it. Nothing to respond to.
That is on record. That cannot be disputed.
Cannot be. But it has to be. It has to be on record.
It'll help Your Lordship while passing the order.
Exactly. Mr. R. Devna, Leonard CGC, has submitted that the records, that the relevant records as called for, have now been produced before this court. The same are accordingly in the custody of the court until further orders. Mr. P. Nongri, Learned Counsel for the petitioner, has submitted that the argument as far as this matter is concerned have been are completed. However, on a query made by this court as far as the submission made that in due course during the pendency of this proceeding the petitioner has since been promoted in the year 2022.
April 2022.
In the month of April 2022, which was also duly noted by this court by its order dated 6/2/2024. 24. The order?
Your Lordship.
That order you referred to? I forgot.
16/4, Your Lordship.
16/4.
16/4, no? Order of this court. 16/2, Your Lordship, sorry. 16/2.
Oh, 16/2, eh? 16/2/2024. However, for the records, the Learned Counsel would submit that an additional affidavit may be allowed to be filed.
Place on record the promotion order.
In this regard. As prayed for, the same is allowed. This matter after 2 weeks.
Item number 8.
Obliged, Your Lordship. I'll place the written argument, please.
Yes,
The hearing has been concluded, so on 2 occasions, time was sought to file our written submission. So, my lord, I'll be submitting to the court master today, my lord. We are ready. This we are submitting, my lord.
We'll be submitting during the course of it. It's being prepared only. Just few formalities are to be completed, Your Honor.
We are submitting, my lord.
Course of the day?
Yes.
Can we receive orders and judgments, my lord, if we are submitting?
Learned Counsel for the parties have submitted that the written argument may be allowed to be filed in course of the day. In view thereof, this matter is now reserved for judgment.
Obliged, Your Lordship.
Item number 9.
My lord, item number 9 is with regard to that particular amount, 17,000. So my lordship has on the past 2 occasions has requested if there can be some kind of, if the matter can be sorted out. My lord, I have spoken to the corporation, my client, my lord. So I have informed them what if something can be done out of the court. So they have agreed, but due to oversight, I was on the impression that this matter is tomorrow. So I couldn't take instruction, but we are calling upon the Dorbashnong, my representative. I informed my senior colleague also. So it'll be at the convenience of my friend also that they can sit together and how to go about with the remaining amount. If something can turn up positive, then my lord will apprise this court, my lord. So I'm praying for time for taking up those issues, my lord, for having a meeting with the petitioner side, my lord.
I think the only resolution that could be foreseen is if they agree and you also agree, the amount of penalty may be reduced, it may be nominal, it may be otherwise.
Installments
There's,
or something.
there's a remaining amount, my lord, of 36,000.
Yes, so
that can be waived off because the remaining has been paid. 50% has been paid.
50% has been paid.
Yes, my lord. The remaining is like somewhere around 17,000, my lord.
It's 36. 36. When we had filed the appeal, we deposited 50%.
Okay.
So remaining amount is 63,312. That is a revised bill. So that can be waived off. We can close the matter at that.
You look,
let the parties settle the matter.
We have already received 50%. Then
well, that the 50% was for the purpose of filing the appeal. So they wanted to prefer appeal. So the rule says that they have to deposit 50%.
Exactly. Now, see, more or
the
less,
remaining amount is the
more
issue.
or less that yes, money is already in your hand.
My lord, it is. It is.
So what remains is for the next 50, if we can.
My lord. So
either
I'm
waive
praying
it off,
that we may be allowed to sit together and how should the matter be sorted out. But if to the earliest, my lord, because this matter is also quite pending for quite long now. So we will inform, if I have the information to myself, I inform my senior friend also, or they will contact the clients.
Ms. R. Kulli, counsel for the respondent, respondent number?
I'm for respondent number
sorry,
326 has submitted that the respondent there is the MECL and there is the Power Distribution Corporation, that the relevant respondent.
Number 5, vigilance or SE.
My lord, I believe it will be proper to direct respondent number 5. 5, my lord. 5 will be in a better position to take up this matter, my lord.
That the respondent number 5. Respondent number 5 has been apprised of the suggestion made by this court as far as the issue of amicable settlement between the parties is concerned. However, as to the formalities involved, the Landed Council would submit that the same have not yet been initiated, since the petitioner is yet to be taken into confidence as far as this matter is concerned. It is the same being informed to the then counsel for the petitioner at the bar, the parties would submit that sometime will be allowed for any solution to be worked out between the parties and for a report to be filed for this court. Accordingly, the parties are allowed to negotiate or sit together for finding an amicable settlement to the dispute and to file a report before this court within the next date fix. This is matter after
My lord, 4 weeks, my lord, a month may be given.
4 weeks.
My lord, the respondent who can take up this matter will be respondent number 6, my lord, assistant executive engineer, not 5.
So I suggest 5 and 6.
Deeply.